I am intimately familiar with Soji because I fought it in Alberta when it was implemented and took it all the way to Adriana Lagrange, the education minister. And I had mothers go into the libraries and pull out books that were available to 8-year-olds that show male-on-male prepubescent oral sex and books about men raping their daughters. And they read this to children. Then they bring in a ginger man and show 76 genders and all these different pronouns. And they make their children as young as 4 play games where they choose their gender and choose their pronoun. And now they have laws in place that if they can convince your little son Jack that he wants to be called Jill, they'll call him her, they'll call him Jill, and they will not inform you, they will not ask for your consent. And then 6 months later, when Jill puts on a dress at your house and you're all concerned, CPS is going to be knocking at your door, wondering why you're not affirming your child's gender. This is about sexualizing children, confusing children, perverting children, so the state can become the #1 influence in their life over the parents, and parents need to stand up to this vehemently and call out these child groomers for what they are. And we need to enforce child exploitation. These are laws on the books that need to be enforced. Thank you. Thank
you. And I'm not playing it a second time. Everybody, we probably got demonetized already. I don't care. First of all, I've seen to make sure that we're good before we carry on. Are we live on Rumble? Let me just see. It looks like we're good. We're good. Let me see that we're live on Locals. Once bitten, twice shy, 3 times traumatized. Everybody, we're good on vivabarneslaw.locals.com. And what else do I have to make sure of? Okay, I can see my face there. We're good. I don't have my good mic. I have my good camera. I've got some lighting. So I'm going to lighten up this side of my face with unnatural lighting. And I got the natural lighting on the right. Oh my goodness. For those of you who don't know who that is or what you just witnessed, Chris Sky or Chris Saccoccia, which his last name is Italian for pocket or sack. Chris Saccoccia, I guess that was at a debate for the mayoral race in Toronto. He's running for mayor in Toronto. We're going to do a follow-up interview from the last one. That was impactful, well delivered. Whether or not, the thing is this, what he said was factually correct in the examples he provided. What he said was insightful historically in terms of in communist states, in communist nations, in times of communism, the state literally said it's like one of the tenets of communism that a parent's love for their child is irrational, but the state's love for a child is rational. Therefore, the state is in a better place to raise a child than the parent because it's rational love and not irrational love. I don't know if it was Trotsky, Stalin, or the other one there, the one with the mustache, Lenin. I don't know who it was. It's a premise of communism. I mean, in a way, it's really a premise of any fascist totalitarian state. They want to control everything. And to do so, they need to destroy the very pillars of a society. What is that? Community, religion, the family unit. They need to destroy all of these things so that they can exercise the influence and not even usurp, but let's just say kidnap, for lack of a better word. Whether or not you think that's what's going on by distance, it certainly is what's going on by way of direction. And what Chris cited there, you know, a lot of people say, look, there's that one picture of the book going around. That's the classic example that everybody uses to say that they're indoctrinating children with inappropriate books. It was one picture from one book. Yeah, it doesn't matter. It still made it in there. Whether or not, I don't know what book Chris was talking about the sexual assault of the father on the daughter. I mean, there are dramatic books that have to tell horrible tales of things that people actually go through. The question is, what age is age appropriate? I've done an interview with the Toronto teacher, Unlearn 16 Joe, who, you know, raises the interesting point. It's on, some of this is on the curriculum already. Where do you stop if you like take out certain books that are upsetting, that contain adult themed stuff, or, you know, R-rated, not R-rated, but adult themed stuff, but for age appropriate? Where does it go? Where does it go when you have parents getting involved in the curriculum as opposed to professionals determining the curriculum? That's the debate. we can agree that there's some gray zone in there where there's going to be the debate, but there's some black and there's some white where there's not much debate. And where there ends up being more fight over the gray zone is when there's a refusal to recognize the blacks and the white zones of this stuff where, yes, that graphic novel containing pornography, inappropriate. And then you have people saying, well, in Florida, they're taking all the books off the shelves. Look what you have, empty libraries. That's how you have to satisfy the capricious nature of this new legislation that they're proposing in Florida. Not fully appreciating that the empty shelves and the exaggerated backlash is just that, exaggerated backlash to prove a political point. Chris Sky's running for mayor of Toronto. He has been ahead of the curve on some things, and he's made some mistakes on others. Nobody's perfect. The only question is, who is of more bad faith and who has been more wrong than right consistently. Let me see. We're all good here. All right. Now, all that to say, people, I'm on the road. I'm going to be back off the road tomorrow night late. Have been in Phoenix and at the Grand Canyon. It's Father's Day, and I'm spending Father's Day with only one member of my family, and my wife is with the other two kids. Happy Father's Day, everybody. Happy Father's Day to the dads out there who, though imperfect, we're all tied for number one dads to the extent that we're trying and we're doing our best. Happy Father's Day to all the dads out there. Now, we're going to have one heck of an episode tonight, and I have a lot of stuff on the intro burner that I want to talk about. I didn't get to stream as much as I wanted to this week because the internet was actually, I can see you in the background. The internet has not been good enough to even upload the Viva vlog shorts. So I couldn't do any more streaming as of last week. My daughter participated in a public speech and debate competition. I volunteered to be a judge, and it was a very interesting experience because for 2 solid days, I was listening to various types of public speaking competitors. And it was an interesting, eye-opening learning experience for me. Now I forget what I was going to say. Yeah, the internet has been so terrible, and it's been a dense week. I couldn't get the streams out, but I got some vlogs out to prep everybody for the show this week. How did she make out? She got knocked out in quarterfinals, which is pretty good. First public speaking event ever. And the competition was good. This was nationals. And so it's like, you know, my daughter, she's finished first and second locally in local competitions. This is nationals where people take it seriously. I would say it's like the Little Miss Sunshine of public speaking, but it's not, it doesn't have the sordid underbelly of pageants. It's just, you know, kids competing, taking it very seriously. So we did that. And then after she was knocked out in quarterfinals, we drove up to the Grand Canyon on Friday. And my goodness, spectacular. Tonight, we've got, well, Barnes will give the list, but Chris Guy's running for mayor. I'm going to do an interview with him this week when I get back to a stable studio. But my goodness, people, has everyone been following? I've been following everything that's been going on in the news. I listened to the Joe Rogan RFK Jr. podcast, put out a little vlog about that on location at the Grand Canyon. If you haven't checked it out, go check it out. You know, when I drove from Florida to Montreal with one kid, we listened to a 62-part miniseries on the fall of Rome. Whether or not the kid understood a word of what was said, he'll absorb that information by osmosis or through osmosis. Now, my other kid, I'm sure she's listened to more podcasts than she wants, more Robert Gouveia breakdowns of the Trump indictment than she wants. They'll absorb the information through osmosis. But I listened to the Joe Rogan RFK Jr. podcast. It was amazing. Everybody should listen to it. The drama of the latest part is that, let me see, I think I have the tweet. Peter Hotez, during the podcast, Joe Rogan was talking to RFK Jr. about his podcast with Peter Hotez. For those of you who don't know, Peter Hotez is the mustache, bow tie wearing doctor guy who has said some things that have not aged very well as relates to COVID response, jab efficacy, et cetera, been very dismissive of alternative points of view, very promoting of the idea that a jab is the be all and end all of any health issue. He was on Joe Rogan. It was also a very, very frustrating podcast to listen to, but I listened to the entire thing back in Florida. Peter Hotez, telling Joe, vaccination, it's the cure. It's what you have to do. And then Joe starts talking to him and saying, Peter, not to be mean, Dr. Hotez, you're not in the best of shape. And he admitted it. Doesn't have the best eating habits, doesn't have the best exercise habits, doesn't take vitamins, supplements, whatever. And yet thinks that, the end goal of health is medical interventions for things that might be, for which the best prevention might be healthy lifestyle, exercise, and other non-medical interventions. So they did, in French, we say les absents ont toujours tort. Those who are not there are always wrong. The absents are always wrong. Joe was talking about his astonishment at Peter Hotez's seemingly mutually incompatible philosophies. One being, I eat junk food, I don't exercise enough, but everybody should take medical interventions to be healthy. And he was talking about it with RFK Jr. And I can imagine being Peter and listening to this and being a little bit miffed. Peter Hotez, drama people. Peter Hotez, after that podcast, puts out this tweet. I might be mixing up some of the timeline because I was catching up as we were on one location to another. Peter Hotez puts out a tweet. It says, Spotify has stopped. What the heck is up with all of the capitalized words? Spotify has stopped even sort of trying to stem Joe Rogan's vaccine misinformation. Ad hominem with no specifics. Imagine you have a tweet and you only have, 200 and some odd characters. And instead of being specific, what the misinformation, you wasted an entire sentence saying nothing. There's a good reason for that. Probably doesn't have much to say. That would actually be specific on point, that could be rebutted or confirmed true. It's really true, and just awful. And from all the online attacks I'm receiving after this absurd podcast, it's clear many actually believe this nonsense. Said nothing. Online attacks. I don't know what that means. Does that mean trolling? Does that mean people, criticizing him online? I mean, does it even mean people calling him names? I don't know what online attacks mean. I don't even know what people qualify as an online attack, but okay, setting that aside. So Peter Hotez puts out this tweet, accuses Joe of misinformation without specifying just one thing that Rogan allowed RFK Jr. to say that was wrong. One thing RFK Jr. said that was wrong. A whole tweet for nuts. Oh, by the way, isn't something's happening to Vice, I think. Isn't Vice, I think Vice is shutting down? I'm not sure about that. Vice had the article. Spotify has stopped even. Oh, that's why it was all titled. Okay, fine. The article to Vice. Okay. Rogan comes out after that and says, come on out for a debate. Debate RFK Jr. Here we go. Let's go down. We have to go here. Peter, if you claim what RFK Jr. is saying is, quote, misinformation, I am offering you $100,000 to the charity of your choice if you're willing to debate him on my show with no time limit. I'm going to tell you something. It's going to be so frustrating, actually, because we'll get there in a second. Joe Rogan says $100,000 to come and debate. What did Peter Hotez say to that? Hold on a second. Let me get the tweet here. Is this it right here? Is this one it? He says, Joe, you have my cell number. I'm always willing to speak with you. Oh, that's nice. Okay. This is a non-answer. I challenge you publicly because you publicly quote tweeted and agreed with that dog shit Vice article. If you're serious about what you stand for, you now have a massive opportunity for a debate that will reach the largest audience a discussion like this has ever had. If you think someone else is better qualified, suggest that person. Large audience. Offer for charity. This is and then there's other people out there saying, oh, why would you don't debate conspiracy theorists? By debating conspiracy theorists, you elevate them. No. In fact, by debating conspiracy theorists who don't know what they're talking about, you actually reveal and expose their disinformation. I could think of some examples, which I'm not going to name offhand because I don't want to put anybody on blast. People who have put out disinformation, and when they then were publicly challenged and had the exchange, it was revealed to be disinformation. This is the bottom line with these hacks and these quacks. They don't want the largest audience possible. They want a select audience of people who already support them. You know, when Trump was on CNN town hall, the biggest complaint from CNN is that the town hall was people who were not in disagreement with Trump. I thought it was going to be the exact opposite. I didn't realize that it was going to be people who are favorable to Trump. They don't want the largest audience possible. They don't want a democratized audience. They want a select audience of people they know are already going to agree with them. And they don't want to debate people who are intelligent and could offer meaningful pushback on a number of material issues. They want to debate with people who ultimately don't disagree with them. It's like when I went to the protest in Ottawa and I talked to one of the people there. I tried to interview a counter protester to the education, not indoctrination discussion. And I say, would you mind talking to me? I talked to 2 counter protesters. We had a good discussion. I actually interviewed a trans person. We had a good discussion. The person says, do you agree with me? Basically, do you support the trans or the anti-trans movement? Just to give them labels. I say, well, I don't support you. Well, then I don't want to talk to you. Why wouldn't you want to talk to me? Because I don't need to talk to you. I already know you're wrong. Who the hell then do you need to talk to? I only want to talk to people I agree with, who I already think is right. Okay, that makes sense. Hotez does not want to have a public discussion about this, because the stuff that RFK has publicly stated, that's in his book, The Real Anthony Fauci, and like Joe Rogan said during that interview, if the stuff in The Real Anthony Fauci is wrong or inaccurate, you would be sued, RFK. And the fact that you haven't been sued is evidence that it's not wrong. And so Hotez doesn't want the biggest audience possible because people will see that he is a bumbling, dishonest quack. They don't want to debate with someone who's smart and debates the opposite point, because that will reveal them as a dishonest quack. And it's not just that. This is the ultimate point. We'll leave it on this because I see Barnes in the backdrop. You couldn't offer Hotez money. Offer Hotez $1 million. He won't do it. I don't think he needs the money. I don't think he needs the money from that source. He'll probably get indirect more money by not doing it. There right now, according to Zero Hedge, the purse for this debate for charity is $1.5 million. Rogan put up 100,000. I think someone else offered $1 million. I forget exactly who. $1.5 million purse for charity if Hotez sits down for this debate. It's not for Hotez now. This is for other people, for charity for other people. He won't do it. He's a coward. He's a dishonest individual. He's a quack. They have all been pushing disinformation and misinformation from the get-go, whether or not it was the origins of the virus to the efficacy of the jab, despite the fact that they were moving at the speed of science and never actually tested it for transmission. The adverse events, which we now know, serious adverse events of special interest, 1 in 800. They won't do it. Cowards, liars, the lot of them. And they want to be surrounded by other cowards and other liars and other people who just want to lick their boots. Okay, before I bring Barnes in, though, hold on a second. Standard disclaimers. No medical advice, no legal advice, no election fortification advice. And we got a sponsor to thank in a second. I was going to do another thing. No medical advice, no election fortification advice. We're going to go to Rumble after 15 or 20 more minutes. Exclusively. So we start on YouTube and Rumble and locals. We cut off YouTube, and then I put the stream and segments back on YouTube later today or tomorrow. We go to Rumble and locals exclusive, and then at the end of this, we end on Rumble. We go over to our vivabarneslaw.locals.com community, where we have our exclusive after party. What are the other disclaimers? I forget. And you may have noticed when you clicked on this stream that it says this stream contains a paid promotion, because it does. Speaking of healthy lifestyle and, nutrients, vitamins, the healthy stuff, exercise, as opposed to just medication. Fieldofgreens.com, people. Powdered greens are not supplements. They're not extracts. Basically, it's like pulverized, dehydrated vegetables and fruits. You get your antioxidants, you get your nutrients from these desiccated, not defecated, desiccated greens. 1 spoonful is 1 serving of fruits and vegetables with all of the super oxidant, whatever the heck they call it. Most people don't know you're supposed to have 5 to 7 servings of raw fruits and vegetables a day. I'll tell you one thing: when you're traveling, it's impossible to get it, and sometimes the fruits and vegetables you get at some places inedible. Field of Greens is a powdered green. Made in America, USDA approved. It's a food, not a supplement, not an extract, and it's fantastic. It tastes good, looks like swamp water, but there's a good reason for that. Swamp water is high in nutrients. It's the water of life. If you go to fieldofgreens.com, it takes you to Brickhouse Nutrition. Promo code Viva, you'll get 15% off your first order. And I'd like to thank fieldofgreens.com. The link is in the pinned comment, and that's it. And how does it taste compared to V8? it tastes much better than V8. V8 is good if you need the salt because you're running a race or something. I prefer the taste of V8, but when you're running races, you need salt. Conspiracy theorists, like experts, are a degenerate meme by established groups to silence critics and protect cowards. Okay, I feel like I'm forgetting something, but it doesn't matter. Bring it in the Barnes because he's been waiting patiently in the backdrop. Robert, 3, 2, 1. Add to stream. Sir, how goes the battle?
Good.
Robert, am I going to be neurotic and ask you to tilt your camera 1 inch to your right shoulder?
Yeah, let's see here. Probably.
This is why, by the way, sometimes OCD is a bad thing because it's good. No, the other way. Let's see. This is how you end up picking at things until they break. Perfect. Robert, I think that we've seen the book behind you. How's everything going? How have you been? I haven't seen you in a week.
Good.
What do we have on the menu for tonight? We got a big show.
Sure. Yeah. The little happy Father's Day, first of all, to everybody out there. I assume you properly told your daughter that quarterfinals was unacceptable and she can no longer use her last name.
I know that she was disappointed because it starts off like you just don't want to embarrass yourself, so you want to get through your
sure,
speech.
but yeah, I mean, she did well getting that far.
It's literally her first time ever at this level of competition. But Robert, I think the thing is like judges.
You can tell her my first speaking competition. I got up, I lasted 30 seconds, started crying, and ran off the stage. So she did much better.
She did quite. No, but the other thing is, like, you see the style that the judges are after. I think they're after more performative, exaggerated deliveries, and not linear. I say more matter of fact presentations. I saw some of them. They're like over the top performative, but maybe that's what that's what you have to give the judges what they want.
Yeah, I suppose so. Yeah, I mean that I think is unnecessary and counterproductive. Teaches kids the wrong things in terms of you got to change your style to match your audience.
I did not. I've learned a few lessons. I might put them together in some sort of like thought analysis for locals, but participating in this event, both as a judge and watching all of it, Robert, they do these things at everywhere. When you were a judge, you have to they make you reflect on implicit biases. There's the whole pronoun things going on. The subject matter. You see when a lot of people speak, you see how identity politics ends up governing or at least influencing all aspects of presentation from substance to form. And I have a lot of observations which I might synthesize later on. But other than that, above and beyond that, it was a great experience. All right, so the menu and sorry, go for it.
No, go ahead.
I'm schwitzing. I'm sweating. I think it's hot in this hotel room. Sorry, yeah. What do we have on the menu for tonight?
Sure. Oh, and just one announcement. I'll be on with the Duran tomorrow, Monday at 1:00 Eastern time to break down a range of geopolitical issues, including the geopolitical implications and ramifications of Trump's indictment, as well as Robert Kennedy's surging campaign and things of that nature. So that'll be the Duran on Monday, 1:00 Eastern. You can find him on YouTube, on the locals, and on Rumble and Odyssey. Tonight, up first, the debate over the censure and fine of Adam Schiff. The journalist, what rights do they have at riots? We got about a half dozen cases from the Supreme Court because they're wrapping up their term that covered everything from criminal sentencing to the False Claims Act and Ketam relief to the rights of Indian tribes to immunity to Indian tribe issues in a case we previously discussed back when it was before the Supreme Court without a decision, the right of adoption in the Indian Child Welfare Act context, as well as rights concerning vicinage and jury trials may impact the Trump case in some cases, venue, which correlates to but is independent of the vicinage requirement, and what is the remedy when the government violates those provisions? Is it dismissal or is it retrial? Then the second most popular choice of the night from our locals board, vaccine case updates. This includes the Texas Guard before the Fifth Circuit against the Biden vaccine mandate and efforts to punish them. Gets into the militia clause and other provisions of the Constitution as well. Brooke Jackson update, relatively brief, but there's an update there. And then the college football coach case went through to the district court motion to dismiss pleading stage. So an update on that. Then the top topic of tonight, though not as much detail as last week, the Trump arraignment and what that means, and the effort by the government to try to prevent him, under the guise of non-disclosure of classified discovery materials, being able to discuss his own records in the upcoming campaign. It's a misapplication of that discovery rule, in my view, as well as what may be coming up, rights to challenge the special counsel appointment and other things of that nature. We have the feds back to the Obama administration protocol of trying to federalize local police under the guise of civil rights representation. We have abortion at issue again. In this case, another conservative court, Iowa, refusing to enforce another heartbeat bill. We have how this issue may be implicated by the personhood debates, which we've had on our locals board about when is someone a person in the meaning of under the Constitution, which goes back to the old personhood debates philosophically, religiously, medically, and otherwise, which took on a new hue this week because they were able to create synthetic embryos. And what legal ramifications are there for that as RoboCop becomes an everyday future reality? We have SBF. There are some charges dismissed. There are some other charges pending motions to dismiss because of extradition issues about what they did with SBF. We got a big win by the Maine lobsterman in a case we've talked about on and off. And last but not least, but the third most popular question on our board, topic on our board, Plato's Republic. When and where does it fail to help constitutional republic or constitutional democracy in our case? So that was a nice little philosophical topic to throw in there because it has some pertinence to the administrative and bureaucratic state and judiciary and the rest.
Robert, can we switch the order and do the SCOTUS decisions first, and then when we switch over to Rumble, do the shift? Because I'm gonna make a specific highlight of shift to bring it over to YouTube afterwards.
Gotcha. Yeah.
Okay.
So we have about a half dozen cases in the Supreme Court context. First one up was sentencing. What was happening? There's some special laws that Congress passed that require mandatory minimums and require consecutive sentences rather than concurrent sentences. So let's say you're convicted of 6 crimes, but it's all the same conduct. Typically, those sentences will be the same. They'll run concurrently with one another. You won't be, okay, you shot somebody, that's assault, 5 years. You shot somebody and they died, that's another 5 years. Things like that. If it's the same crime, same sentence, and thus concurrently run. But there's some statutory provisions where Congress required not only minimum sentences, but mandatory consecutive sentences. And they usually concern where drugs and guns intersect. And there's basically a provision that says where drugs and guns intersect under this statute, you have to, under this subsection, issue consecutive sentences. The Supreme Court said that only applied to that specific subsection, did not apply to other subsections, even though they may seem interrelated, be part of the same statute, be part of the same policy schema. I think what it really represents is the court's disliking mandatory sentences, whether they're mandatory minimums or mandatory consecutive sentences. Some parts of the court not liking it targeting drugs, other parts of the court not liking it targeting guns for unique harsh criminal punishment. But the Supreme Court basically allowed for concurrent sentences in a lot of drug and gun cases and limited the scope to which those mandatory consecutive sentences apply.
I'm just thinking of, in a case like Trump where he got 37 charges on an indictment. Well, if you get 37 consecutive sentences, he'll be in jail for however many hundreds of years. I know we've talked about this, and I think your view on mandatory sentences is you don't like them, correct? Like you'd rather leave it to the discretion of a judge.
Generally not a fan. It represents legislative distrust of the judiciary, which I share. But my view is all sentencing should be given to juries. Juries should decide sentences, not Congress, not prosecutors, not judges.
Yeah, but you still hold that view, having seen the way juries are convicting based on highly politically motivated reasons in Washington. Oh, sorry, in Washington and in New York.
Yeah, it's still they may convict, but I would still prefer they issue sentences. My guess is even those politically hostile jurisdictions where the sentences have been just as harsh by the judges anyway, that you're going to get more hospitable sentencing from the jury than you will a judge, because in those liberal jurisdictions, a lot of them don't like over incarceration, things like that. So
That depends on who, Robert. They don't like over incarceration,
sure.
depending on who. No, I guess from a jury's perspective, there's always perhaps more of that always reflection. This could be me at some point,
Right.
versus a judge, maybe not.
Plus, they don't, outside of really violent, dangerous criminals, they generally don't like long prison sentences. Juries. Judges are much more punitive than juries on average when it comes to that. The people they're really punitive towards are your really dangerous people. They'll be more punitive than a judge on child pornography charges, child molestation charges, sexual assault charges, certain kinds of a burglary of a home, home invasion charges. The kind of things that really, in my view, deserve harsher sentences is where juries will be harsher. In your typical, dispute with the government, regulatory, political protest gone AWOL case, your jurors don't like long sentences and are often surprised when they find out how long the sentences are based on their verdict.
That's interesting. Okay, cool. The next one, Robert, a False Claims Act. This is. I mean, sometimes I say I know exactly why you're sending me a decision. So this is a False Claims Act where it was a doctor who filed a qui tam suit, which is, I guess, more simply put, not in lieu of, but pursuing fraud that was perpetrated against the state on behalf of the state, and then the state has the option of coming in and taking over the case for the person who filed it. First of all, Robert, I'm reading the lawsuit, and I thought it was a realtor who was filing a False Claims Act based on Medicare fraud, and then I realized I'm reading relator, which is the person who initiates the action, as realtor. I was like, why is a realtor filing a False Claims Act for medical fraud? The basis of the lawsuit, which is interesting enough, and I think it explains why the government took it over to kill it, is basically the medical industry providing false claims to the government, which then get reimbursed which get refunded or reimbursed by the government. And it's basically fraud perpetrated for the benefit of the medical industry, by the medical industry, and sanctioned, facilitated by the government. This doctor, he spent a little time looking into it, files a False Claims Act on this grounds. There's a 2-year investigation in which the government is deciding whether or not to take over in lieu of the relator, and they ultimately decide not to. And the litigation goes on for years, investigating doctors basically providing fraudulent claims to the government, which get reimbursed by the government. And you'll tell me if I'm making mistakes here. The government decides a couple of years into this lawsuit progressing, they're finally going to intervene to, what's the word? To kill the lawsuit, to end it, to dismiss it. And the relator, the guy who's invested time and I presume money into this suit, says, no, the government had the option to take my place within whatever the short time frame at the beginning is, decided not to. If it decides to intervene at a later date, it can do so, and it becomes a party to the suit, but not the principal claimant, for the purposes of dismissing the lawsuit outright, so that, lo and behold, nobody can investigate this apparent fraud between the medical industry and the government. And this went to the Supreme Court. I forget who the dissenting opinion was, but ultimately the Supreme Court says, now the government can intervene whenever they want for good cause. And if they decide to kill the lawsuit, that's their prerogative. And the relator, the person who's filed this and taken it the distance, has no say, no right, no nothing to oppose it. Have I made any mistakes on the details?
No, that's pretty much it. I mean, essentially, the government took the position that they could move to dismiss without even intervening in the case, which was, to me, a preposterous position. The Supreme Court did unanimously reject that government interpretation. They said, no, you have to be a party, and you're only a party if you intervene. But they rejected the relator's position that their failure to intervene during the seal period barred them from having the power to dismiss at a later stage. And they don't meaningfully enforce that good cause provision for a post-seal intervention. So, I mean, I favored the relator's position. The government should either get in or get out. And when it gets out, it shouldn't be able to selectively get back in outside of exceptional circumstances that they didn't evidence here. But that's more of a good cause debate than it is whether or not they have a right under the rule to re-intervene post-seal. But the other aspect was what Justice Thomas dissented upon and what two justices concurred in part on his dissent, which was his view was the government could only be a party for purposes of dismissal if they intervened during seal. But he had another reason for that. His argument was that a private citizen, Congress cannot give a private citizen Article 2 power to seek injunctive relief unless it's under a different clause than the one they've used. And basically, he suggested that the property clause could be a proper claim for assigning the government's right to an individual, but once assigned, they couldn't retake back that assignment. And thus, it would still be only during a seal that they could intervene. But his argument is that we should reassess why and how we allow individuals to bring suit in terms of what Congress authorizes, and that maybe we're using the wrong constitutional provision because that has implications and ramifications for not only False Claims Act, but any other claim and a wide range of other suits about Article 2 power. When do private individuals, when can they be given private attorney general status? And under what constitutional clause is allowed? And his point is the necessary and proper clause that's been cited is not sufficient. And also that once the assignment is given, that it should be effectively non-revocable, such that the government can't change their mind later and screw the person who decides to proceed with the case. So I generally sympathize with Thomas's dissent in the case. Two other justices suggested that a future case would be the right case to look at that. Otherwise, the Supreme Court basically split the baby in terms of denying both sides what they wanted.
But Robert, if the government can elect not to intervene pre-seal, but they can intervene post-seal for good cause, I don't know what that means under American law, and they can decide to intervene after post-seal for good cause to kill the suit. I don't want to give anybody any ideas, but why wouldn't the government then, let's just say it knows it's a dangerous suit. This particular case might expose collusion between government and Medicare fraud. Let's take another case where it might expose collusion between the government and pharmaceutical fraud. And what the idea that they could intervene to kill the suit so that no one has any rights, I guess this gets back to a constitutional violation, but is there a risk? Is this going to now encourage the government to do the same thing potentially in the Brooke-Jackson lawsuit?
Oh, they always could have done that. Now they can't because the case is on appeal, so that they're not in a position to do that. But in all cases, the government does this routinely. The Supreme Court mostly limited their ability to do it. Before the Supreme Court's case, the government's position was they could move to dismiss without even requesting intervention. So now at least they have to show a court they have good cause to intervene and have to go through the formality of intervention. And in my view, dismissal is not good cause by definition. So that issue is yet to be litigated. It wasn't litigated in this particular case, at least not at the Supreme Court level. But yeah, the government's always had this power. They can step in, dismiss a case, kill your case, no matter what, on any grounds they want. And it's very difficult to stop. And so it's the hurdle in the process.
Okay. The other Supreme Court, the Indian tribal immunity, Indian adoption. We talked about this one a couple of times. Refresh my memory, Robert.
Yeah, so there are two different ones. There's Indian tribal immunity and Indian tribe adoption issues. So the first one was Indian tribe immunity, which is a bankruptcy. Basically, somebody owed money to an Indian tribe, filed in bankruptcy court to get rid of the debt. And the Indian tribe said, we're not subject to bankruptcy law. We're a separate sovereign. And the bankruptcy waiver of immunity lists every government known to man except Indian tribes. The Supreme Court decided that that was kind of accidental, and that because all the other governments lose their immunity in bankruptcy, Indian tribes do. Gorsuch, a longtime Indian tribe advocate in terms of rights constitutionally, disagreed, saying, look, if Congress wanted Indian tribes to have their debts or their creditor claims dischargeable in bankruptcy, they would have said Indian tribes in the immunity waiver, and they chose not to. So I think Gorsuch has the better statutory argument, but the Supreme Court wasn't going to interfere with bankruptcy They defer to the bankruptcy courts all the time and have expansive interpretations that favor every creditor, except in this case, Indian tribe creditors who didn't want to be part of it. So that's ultimately where the case went. Thomas argued that Indian tribe immunity, he's not a big Indian tribe immunity fan. I disagree with him on this. And that he believes that it only applied to commercial activity anyway, the scope of Indian tribe immunity, because he said it's rooted in the common law rather than the Constitution. I think Indian tribe immunity is actually in the Constitution under a principle called treaty federalism, best articulated by old professor of mine, Richard Monette. But that's where Thomas came down. But the majority opinion was that bankruptcy is a place where you can also discharge your debts to any government, including Indian tribes.
All right, interesting. I mean, this, I guess, the segues into the second one, which was the native adoption, or the law that prioritized adoption of native children by native tribes or biological native, not necessarily family members, but within the native community, was challenged 7-2. Supreme Court says it's not. Did they say it's not? It is discriminatory, but justified, or not discriminatory?
They don't reach that part of the issue. So they claim there's no standing by the people to sue on the equal protection part. So the first claim was that the Indian Child Welfare Act was just unconstitutional because it was not within the authority of Congress to govern matters of family law, and the matters of family law should be left to the states. And that the Supreme Court rejected. And Gorsuch explained in a concurrence with Jackson and Sotomayor, you're seeing a lot of alignment between Gorsuch and Jackson on civil liberties issues and civil rights issues, that this is due to the unique constitutional structure of Indian tribes and the unique legal history and political history of Indian tribes. Namely, what used to happen on the history part, the constitutional part reflects Richard Monette, my professor's argument about treaty federalism and Indian tribes using those treaties being treated like quasi-state sovereigns, like the state governments themselves, and that it creates its own form of constitutional recognition and respect for Indian tribes, which I agree with. The historical part is that there's a long, bad, ugly history of Indian kids being kidnapped and being taken out of tribes to be acculturated by different values of non-tribal community. So in response to that, Congress passed the Indian Child Welfare Act when Native American issues became a hot button issue in the 60s and 70s, that said that in the future, any tribal member will try to keep placed with a tribe or another Native American rather than non-Native American sources of power. And the Supreme Court said that both that all the different provisions of the Constitution referencing this kind of treaty federalism, including the Indian Commerce Clause, the Treaty Clause, combined with the historical legal power of Indian tribes vis-a-vis state governments under federal protection, made the law constitutional. And they said the issue of equal protection analysis was an issue that these particular plaintiffs weren't in a position to raise, and so they weren't going to get into the discrimination claims and leave that for another day. They also said that the other challenge that was brought was that this was the anti-commandeering doctrine of the federal government co-opting state sovereignty to do federal tasks. And the argument was because this applies to private citizens and the state governments alike, there's no specific usurpation of state sovereignty in the laws. So the Indian Child Welfare Act was upheld as constitutional on those grounds as well. But I think the unique treaty federalism components that Gorsuch explains are very pertinent. And the history of the political context of this is also relevant to understanding why this law exists in the first place. But it was, not a very common Indian-related issue, but for the legal issues that are more broader in conceptual framework, I recommend Gorsuch's concurrence in the decision.
It's interesting. I'm not sure if there's an equivalent in Canada, but the idea that once upon a time adoption out of the tribe was the best interest of the child because assimilation was the only way of incorporating native
that
kids.
That was the same here in America for a long time before this law. Thomas and Alito dissented on grounds they don't think Indian tribes should have any such recognition, and they think states' rights trump Indian tribes. I disagree with them on that issue.
All right, and last one. This is the last one, I guess, before we go over to Rumble. A trial conducted in the wrong venue, and I guess the question is whether or not you have a retrial, unless it violates the provisions of the speedy trial constitutional rights. What were the details of this one, Robert?
So basically, they tried somebody in the wrong place, and they kind of knew it. They got a conviction. The courts overturned it, and the defendant's argument was he shouldn't have to face retrial. And the remedy for knowing violation of venue and vicinage provisions, because both of them should be dismissal with prejudice, not retrial. Because then the government really isn't punished very much.
Mm-hmm.
Supreme Court disagreed, and they said for pretty much everything outside of speedy trial and other unique circumstances, we're always going to say retrial is the remedy. Now, I often use that to hammer appeals courts to say, what are you so scared of when you know a court made a mistake in a criminal case? The worst thing they have to do is just retry them. But it doesn't work that way. The courts still affirm at an 85-90% rate a criminal conviction, which tells you what a crock our court of appeals are in America when it comes to federal criminal cases.
Well, set aside the fact that it was knowingly or negligently in the wrong venue. I mean, even if it's done as a good faith mistake, I guess it's not double jeopardy insofar as trial and conviction set aside for venue it's not double jeopardy because there hasn't been jeopardy attached because it was in the wrong venue. I mean, it doesn't make sense to me, but I'm thinking I might be missing something.
Oh, you're not missing anything. I mean, to me, there's two constitutional provisions in play. So venue is that under the Constitution, you can only be tried in the state where the crime was committed. The vicinage provision is a jury right provision. So it's separate. So venue is it in the state where the crime was committed? Vicinage is the jury selected from the state and district where the crime was committed? So that's where a case the jury pool has to be drawn from a different district than the venue itself, in the sense that it's more specific. So here, the venue was wrong, the vicinage was wrong because the state was wrong. But the Supreme Court, without dissent, of course, was like, oh, your only remedy is retrial. No big deal. As long as double jeopardy doesn't attach, and it doesn't attach because you were convicted. So that's it. Well, to me, it really waters down the enforceability of those provisions when the government knows they can effectively get away with it. That the worst thing that will happen to them is they just get to retry the case.
Kind of like having a confidentiality or a non-compete that's too broad, unless it's struck entirely and the person who tried to be too broad is punished. There's no incentive or no deterrence to just go too broad. And if you screw up, hey, I'll get a second kick at the can later on. All right, now hold on, Robert. We're going to move it on over to Rumble, but before I do that, let me just grab the super chats here. I'm going to put the link in one more time, everybody. Head on over to Rumble, 3,000 people, and it should be decreasing. But before we go there, just to bring up the super chats here, conspiracy theorists. Okay, I got this one before. RFK Jr. will get Bernied. This wasn't a super chat. This was just a comment, and I just wanted to say, so long as all he gets is burning. I don't like even having the thoughts, but if he gets too popular, at the end of the Joe Rogan podcast, he acknowledged when Joe Rogan asked him, he acknowledged the real risks. These are not like hypothetical neurotic concerns. Would I vote for Trump in jail? No, because I haven't been arraigned yet. Okay, hold on. We got breaking. Florida introduces death penalty for espionage charges. I think this is a joke. I hope it's okay. I think it's a joke. And then we got Barnes. Are you ever going to reach out to Solomon Anderson about your offer to help with Zach's appeal? And then there's
when I get time, yeah.
And we got Free Zach R.I. Anderson. Looking forward to reaching out to Zach's family. Kayla,
people can continue to support the fundraising for his camp, for his effort too.
I'll share the link for that.
Wasn't he on with Eric Hunley this week?
He was on with Hunley. I thought it might have been the week before, but he's been. I mean, Zach's brother is really working hard to get this out there and make sure everybody knows. So I'll send the link to the Give Send Go in a second. Happy Father's Day, gentlemen.
You forgot you interviewed him.
Yeah. Oh, yeah. That was it. I just got one of the few comments on the podcast version. Someone says, I just finished this podcast. It's the most infuriating thing to listen to. Happy Father's Day, gentlemen. Barnes, will you have Solomon Anderson to speak about the... Oh, no, yeah, we had him on. I had him on 3 weeks ago. Viva, having Jordan Peterson on anytime. I wonder if I'm not too toxic for Jordan. I would love to. So maybe one day it'll happen. Okay, what we're going to do now, we're going to end it on YouTube, move on over to Rumble. No, I just opened up a new window. I want to just close it on YouTube. Go to Rumble and then to Locals, vivabarneslaw.locals.com. Removing now 3, 2, 1.